In the complex tapestry of modern governance, administrative law emerges as a crucial thread, regulating the vast powers exercised by administrative agencies. It ensures fairness and accountability. This branch of law governs the activities of administrative agencies of government. These agencies can be part of the executive, legislative, or judicial branches. Administrative law is dynamic and ever-evolving, reflecting the changing needs of society. It is not a static body of rules. It is a living system of law. This system adapts to the challenges of modern governance. One prominent definition of administrative law comes from Ivor Jennings. He states that administrative law is the law relating to the administration. It determines the organization, powers, and duties of administrative authorities. This definition emphasizes the broad scope of administrative law. It encompasses the structure, functions, and limitations of administrative bodies. Administrative law sits at the intersection of legislative, executive, and judicial powers. It draws elements from each branch of government. This blend of functions gives administrative law its unique character. It is both procedural and substantive in nature. Legislatures create administrative agencies and grant them powers through statutes. These powers allow agencies to make rules, conduct investigations, and adjudicate disputes. This is the essence of administrative law in action. However, the grant of power is not unlimited. Administrative law also recognizes the importance of judicial oversight. Courts play a vital role in ensuring that administrative agencies operate within the bounds of the law. They review agency decisions for fairness, reasonableness, and adherence to the law. The scope of administrative law is vast. It touches upon various aspects of our lives, from environmental protection to consumer rights, from immigration to healthcare. Its influence is pervasive, impacting citizens and businesses alike. This highlights the growing importance of understanding administrative law in today's world. The sources of administrative law are diverse. They include statutes, which are laws passed by legislatures, often creating administrative agencies and defining their powers. Regulations, which are rules made by administrative agencies themselves under the authority granted to them by statutes. Judicial decisions, with court rulings interpreting administrative law principles and agency actions forming a crucial part of administrative law. And common law, where general legal principles developed through court decisions also play a role in shaping administrative law. Two fundamental principles underpin administrative law: the separation of powers and the rule of law. These principles act as safeguards against the arbitrary exercise of power. They ensure accountability and fairness in administrative decision-making. The separation of powers divides governmental authority among the legislative, executive, and judicial branches. This division aims to prevent any one branch from accumulating excessive power. Administrative law recognizes this separation. It seeks to ensure that administrative agencies, while exercising powers delegated to them, remain accountable. The rule of law dictates that all government actions, including those of administrative agencies, must be authorized by law. It ensures that agencies act within the limits set by statutes and the Constitution. This principle is crucial for a just and predictable legal system. Section 5. The Principles of Natural Justice. Natural justice is a cornerstone of administrative law. It encompasses two fundamental principles: the right to be heard, or audi alteram partem, and the rule against bias, also known as nemo judex in causa sua. These principles ensure fairness and impartiality in administrative proceedings. The right to be heard dictates that individuals affected by administrative decisions should have a fair opportunity to present their case before a decision is made. This includes the right to receive notice of the proceedings, to know the case against them, and to present evidence and arguments in their defense. The rule against bias prohibits decision-makers from having any personal interest in the outcome of a case or any prejudice that could influence their decision. This ensures that decisions are made objectively based on the merits of the case and not influenced by extraneous factors. Section 6. Delegated legislation and its control. In modern governance, legislatures often delegate some of their lawmaking power to administrative agencies. This is known as delegated legislation. It allows agencies to make detailed rules, and regulations within their areas of expertise. This delegation is essential for efficient and effective governance. However, delegated legislation raises concerns about accountability and potential abuse of power. To address these concerns, several control mechanisms are in place. First, legislative control. Legislatures retain the power to revoke or amend delegated legislation. Second, judicial review. Courts can review delegated legislation to ensure it is consistent with the enabling statute and the Constitution. And finally, procedural safeguards. Agencies are often required to follow specific procedures when making rules, such as public consultations, to enhance transparency and accountability. Section 7. Administrative discretion and judicial review. Administrative agencies often have a degree of discretion in making decisions. This discretion is necessary to apply broad statutory provisions to specific cases. It allows agencies to consider individual circumstances and exercise judgment. However, administrative discretion must be exercised reasonably and within the bounds of the law. Judicial review serves as a check on the potential for abuse of discretion. Courts can review agency decisions to ensure they are reasonable, based on evidence and procedurally fair. Section 8. Writs and administrative action. In India, citizens can challenge administrative actions through writs, which are orders issued by the High Courts and the Supreme Court. The Constitution of India guarantees these writs as fundamental rights. They serve as powerful tools for upholding the rule of law. The 5 types of writs under the Indian Constitution are habeas corpus, which is used to secure the release of a person unlawfully detained; mandamus, which compels a public official to perform a mandatory duty; certiorari, which is used to quash an order passed by an inferior court or tribunal; prohibition, which prohibits a lower court or tribunal from exceeding its jurisdiction; and quo warranto, which questions the legality of a person holding a public office. Section 9. State liability. The concept of state liability holds the government accountable for the wrongful acts of its employees. This principle is based on the idea that the state should be responsible for the actions of its agents. It is an essential aspect of administrative law. Vicarious liability is a specific form of state liability. It holds the state responsible for the torts or civil wrongs committed by its employees during the course of their employment. This liability arises even if the state itself was not directly at fault. It ensures that victims of administrative wrongdoing have a legal remedy. Section 10. The Ombudsman's role. An ombudsman is an independent and impartial official who investigates complaints against government agencies. They act as a watchdog, ensuring administrative fairness and accountability. The Ombudsman's role is to resolve complaints through mediation, investigation, and recommendation. The Ombudsman's office provides a valuable avenue for citizens to seek redress for administrative injustices. It helps to maintain public trust in government by providing an accessible and impartial mechanism for resolving complaints.